Hi, welcome. I'm Tom Maloney. I'm the chair of the Department of Economics here at the University of Utah. And I want to welcome all of you to this conference on the new merger guidelines, controlling case law and new economics. The conference is organized by the Utah Project, which is a collaboration between economics faculty and faculty from the S.J. Quinney College of Law, specializing in antitrust and competition policy. The conference is supported by a generous grant from the Economic Security Project, and we also have funding from Charles River Associates and Keystone Strategy for some of the events and meals later today, so thanks to them. It's a real honor to be able to host this event and this remarkable group of scholars and policy experts. Our economics department here at Utah prides itself on approaching economics as a subject that matters for the real world, beyond academic discussions, beyond academic journals. We want our students to have a rigorous understanding of economic theory, but we also want them to develop a deep knowledge of institutions and practices in the world and to connect that theory to the world in a useful way. We also take pride in our pluralist approach to the field, studying dominant paradigms, but also confronting those dominant views with serious critiques and alternatives. And related to that, we take seriously the need for economists to understand the history of the discipline and the evolution of schools of thought and key ideas, as well as the connections between the evolution of economic ideas and the political and social context in which those ideas are developed and diffused. And finally, we really value the importance of interdisciplinary work for providing deeper insight into the problems we want to address. And I think all those values, the values that are really central to our department, are very, very well represented in today's program and more generally in the work of the Utah Project. So that's very gratifying. I want to add that as a graduate student, I was never drawn to industrial organization or antitrust issues or competition at all, and didn't really know the first thing about them. I spent my own time engaging in economic history, especially in sort of labor and demographic topics. But beginning with the fall 2019 conference we had here on a new future for antitrust, my colleagues here at Utah, others involved in the Utah Project, and those who participated in the events that the project has organized have provided novices like me with a terrific introduction to the intellectual excitement around these issues and the real gravity and importance of the ideas we'll be talking about today. So I want to thank them, and many of you, for that. And I also want to thank the staff of the Economics Department, the S.J. Quinney College of Law, the Alumni House, and others at the university who've made this event possible. Please join me in thanking them. Thank you. And now we're caught up. I now want to introduce George Contreras, professor of law at the S.J. Quinney College of Law, specializing in antitrust and intellectual property, for some introductory comments.
Well, good morning, everyone. Let me join Dean Mahoney's welcome to you to this conference on the new merger guidelines. As he mentioned, I'm George Contreras. I'm a professor of law here at the University of Utah. I'm also the director of the program on intellectual property and technology law here at our College of Law. And I worked with Mark Glick and others in the Department of Economics on creating this Utah project on antitrust and consumer protection law and economics, which hopefully will soon be an official center on campus. So again, the process is not quite complete. And also let me echo the sentiment that Dean Maloney mentioned of the University of Utah's history of engagement with federal and state antitrust policy. This goes back quite a while, to at least the 1970s through the 1990s. Professor John Flynn, who was at the law school, both a lawyer and an economist, championed the efforts by economists and lawyers to create an intellectual pushback against the quote unquote Chicago school of antitrust theory that had grown to prominence beginning in the late 1960s. Professor Flynn was also a leader and probably the creator of the field of antitrust federalism. And he also played a key role in drafting Utah's constitutional free markets clause, which still remains unique among the 50 states as a constitutional right to a free market enshrined in the Constitution of this state. So, as you've already heard, in 2019, the University of Utah organized a conference of leading progressive legal scholars, economists, and judges, featuring a number of luminaries, including Lena Khan, who is now chair of the Federal Trade Commission. One outcome from that conference was the Utah Statement, subtitled Reviving Anti-Monopoly Traditions for the Era of Big Tech, a new framework for holding private power to account. Professor Tim Wu at Columbia University, who was recently Special Assistant for Competition and Technology Policy at the White House, referred to this document as groundbreaking and crystallizing a new view of antitrust policy. We followed up on the 2009 conference last year with the Utah Law Review's annual symposium titled The New Roaring Twenties, the Progressive Agenda for Antitrust and Consumer Protection Law. Chair Khan again spoke, as did a range of federal and state officials, legal academics, and economists. The results of that conference were published in a special issue of the Utah Law Review, which came out earlier this year. And I think we have reprints from at least one of those articles back on the table, if anybody wants them. So the University of Utah is unusual in that it has both economics and law professors who focus their research on antitrust policy and consumer protection. The state of Utah also has a very active antitrust bar, and several of our federal district court judges, our attorney general, are antitrust specialists and enthusiasts. Utah's Silicon Slopes area, which you can see if you just drive south on I-15, is quickly becoming a node in the digital economy, with especially influential role in IT services for banking, finance, and data services. So given this emphasis on antitrust law and regulation, we're pleased to gather today this all-star cast to discuss the 2023 Department of Justice Federal Trade Commission draft merger guidelines. And we invite you all to participate and engage with the speakers and the panelists, either during the Q&A sessions or afterwards at the breaks. If you would like to tweet or post about this event, we have a hashtag Utah Project, that we'd invite you to use. And so with that, I will turn it over to Mark, who can introduce our first panel. Thank you. I'd like to invite the first panel to come up.
So welcome again. Our first panel is about platform mergers, which is guideline 10 in the new draft. But 7, 8, and 9, entrenchment, trends toward concentration, and serial acquisitions are also very relevant for platform mergers. The way we organized the first panel is Susan Athey is going to start us off with a summary of the new guidelines and their rationale, and she's going to outline how platform mergers are analyzed. And then I'm going to pose some questions to the panelists, and hopefully they'll give us short, concise answers and allow the other panelists to react and interact between each other. Hopefully we're starting a little early, so we'll have time for audience questions as well. So let me first introduce our panelists. Susan Athey is the chief economist with the Antitrust Division of the Department of Justice. She's on leave from Stanford Graduate School of Business, where she's the Economics of Technology professor. She has numerous publications in the area of platform economics. Early in her career, she won the John Bates Clark Medal for the best American economist under the age of 40. She's the 2023, that's this year, president of the American Economics Association. I've worked with Susan for many years, and she's simply one of the smartest people that you're ever going to meet. Nancy Rose is the Charles Kindleberger Professor of Applied Economics and the former chair of the Economics Department at MIT. She's currently a visiting scholar at the Kennedy School at Harvard. Previously, from 2014 to 2016, she served as the Deputy Assistant Attorney General for Economic Analysis at the DOJ's Antitrust Division. And before that, she oversaw the NBER program in industrial organization for 23 years. She is, of course, the author of numerous important papers on antitrust. Rebecca Howe Allensworth is the Associate Dean for Research and the David Daniels Allen Professor of Law at Vanderbilt Law School. Her main research areas are professional licensing and antitrust law. Her work on antitrust focuses on technology platforms. She's been cited by the Supreme Court. She's advised 3 presidential administrations and has testified several times before Congress. She's regularly featured in the New York Times, NPR, CNN, and the New Yorker. She received her law degree from Harvard Law School, and she clerked for Judge Richard Posner, if you've ever heard that name before. Andrea Coscelli is a PhD economist and antitrust expert in European competition law. He was the head of the UK's Competition and Markets Authority for 6 years until July 2022. During his tenure, the CMA took an active role internationally in digital platform mergers and antitrust cases in the tech industry. The CMA was also the first agency to create a dedicated data and technology unit under his leadership. He's now head of the Keystone Strategy European competition practice. Okay, with that, I'll turn it over to Susan for her opening remarks. 30 minutes, maybe. And we have some slides. Could you project the first slide? Is that what you want to sit here or?
Maybe I should stand up.
Sure, absolutely. Absolutely.
Do I have a clicker? Mark, okay, if we go to here so we can see Susan.
Sure, absolutely.
But sorry, do I have a clicker or I just need to ask to advance? Thank you. So first of all, thank you everyone. Thanks to people for being here and thanks to everyone for tuning in. I should give the usual disclaimer. I'm speaking, my comments here are my own and not necessarily representing any particular agency. We have been doing a lot of these, and so I have to say that though each one has been really helpful, and one way to frame this entire project is that this is the guidelines are really a project that is kind of owned by the agencies, but also the community. And so I feel as a drafting team, our team are the stewards of this project. What's been really amazing out of all of this is how many people have devoted their personal time and so many hours into trying to get to a good outcome. So thank you to everyone who's contributed. We got thousands of pages of comments, and we've been reading them and reading them carefully. Of course, one thing that's interesting about this whole project is it's not that that you need a new theory. There are way too many theories. If you ask one lawyer or ask one economist, you'll get 3 theories, and then the community on any particular point, and we see this in the comments, have very strong views on should it go this way, should it go that way, but it's not just make it tougher or more lenient. It's also how you phrase it and how you frame it. So all of that is what we're internalizing now. And for me, I've really viewed this as a listening project, because really these words don't mean anything until you think about how they work with cases. And so it's the fact that the community on each case has spent weeks in a conference room on one line in a guideline, or thinking about what the ambiguity is. That's where really the content is that we then bring together and synthesize in these guidelines. So we're still listening. So it's very active. And so I'm really excited to hear the comments today. So one of the things that was different about these guidelines is they're structured slightly differently. And I think that's taken some folks a little while to wrap their heads around. But I think as we get to these, they've been out for a while. We're now kind of moving past the changes in structure. Just for those of you who haven't been living and breathing this for the last year like I have, to remind you what this new draft guidelines framework looks like, we start with the prima facie tests. So from an economics perspective, like these are the theories of harm. These are each ways in which a merger might create the risk of a harm to competition. And they actually have 2 different types. Some of the guidelines are more like kind of, I would say, core theories that are more distinct from one another, although even there, they may be overlapping theories. So for example, For a horizontal merger, you can think about coordinated effects or unilateral effects. And so those are different guidelines. So multiple guidelines might be at play on any merger. And then the later guidelines, which include platforms, are applications that might cross multiple frameworks. And so and so people have often asked, well, if the core frameworks are already there, why do you need additional guidelines if they're not introducing new theory? And so I'll be trying to, this is a little bit of showing rather than telling, but to me, the platform section is one of the big examples where that's useful. And I know that from thinking about platforms in the antitrust space for a long time, it's just complicated. There are multiple steps. And if our teams are trying to investigate and they're trying to put together all of these theories from scratch, it's hard. It makes the work for our investigative teams harder. It makes it hard to communicate with parties when they're coming in if there's multiple steps of logic that are all fitting together. And then when you're going to write expert reports, it's really helpful if the expert doesn't have to start from first principles and start their report with 5 steps of logic. And you worry that the judge is going to wonder, are you making this up? It couldn't possibly be this complicated. You're like, I'm sorry, platforms are a little bit complicated. I can't make them completely uncomplicated. And so that it's getting us to the starting point. Labor, which we'll talk about later today, is another example of that, where that people have a lot of, it was stated very clearly in 2010 guidelines that the things that monopsony is symmetric and that it's important and that, that's all there. And we brought cases involving labor under the 2010 guidelines. So that's also all there. Nonetheless, people still wake up at the beginning of each case and say, well, but do they really mean this? And so on. And so spelling it out and making it clear lets you not have that full debate, but just start with the facts. We have market definition, which I decided I'm not going to talk about today in the interest of time, and rebuttals, which I'll say a little bit about. And then we have evidence and economic tools, which are separated, and that's partly because they are used in multiple guidelines. So in the 2010 guidelines, there were a lot of things that were in the unilateral effects sections about measuring competition. But because we have horizontal and non-horizontal mergers in the same guidelines, you may need to be measuring or assessing competition in more than one place. And so they've been pulled out and used there. Now, one piece of feedback, and I'm going to throughout my comments, I'm going to be sprinkling in really helpful feedback we've gotten already and hoping also that will tee up the panels. One piece of feedback we got was that there were some really important things that were kind of buried in the economic sections about how we measure competition that were sort of implicitly defining what we meant by competition. So at first, when people said it's not there, I'm like, well, it's right here. This is how we do it. But one thing my colleague Dave Lawrence analogy likes to give is there's a little bit of like the director's cut of a movie. So at the end of the drafting, we were cutting paragraphs that were redundant. We had a bit of a page constraint we were trying to hit. We had been at 100 and we had to get it down. And so we cut things that were duplicative, and especially things that were hard to write in duplicative because you don't want to say the same thing 2 different ways if it's important. But we cut out some of that duplication, which I think the feedback has been very clear that some of those cuts really changed the way people read things. And so that's something that we're going to be thinking really hard about, is putting those things back in, unburying them and elevating them, because it does make a difference in how people consume them. So that's the structure. And then another thing that was a little bit unclear in how people read these, which we've heard loud and clear, is that it was a little bit unclear that all of this economic analysis applied to both rebuttals and the prima facie cases. So we talk about the law telling us about a risk of harm to competition. If we say this, we say in the prima facie cases, this is how competition might be harmed. And then the rebuttals say, you're going to look at, no, I don't think competition is going to be harmed in this way. And the same tools and frameworks would apply to both. And again, that's a bit of feedback we've gotten that we're listening to. So stepping back in terms of the conference today, why update the guidelines? Well, the things we're talking about today are a big reason why. So one of the things we always want to do is make sure that we are reflecting on the guidelines, the complexities and the patterns that we're seeing. So we say, is something worth spelling out? One thing is it's complicated and confusing. It may be worth spelling out. Another thing is just that it's important and it's something that we're seeing. And so it's pretty hard to argue that platforms aren't very important in our economy today, and that we also see a lot of concentration there, and we see a lot of important mergers there, mergers that are might affect the entire economy. They might affect how many firms get information to their consumers. They might affect the cost of payments for big parts of the economy. So these are super important. And because they're important, the economics and the legal community have put a lot of time into thinking about them. And so we've learned from experience whether competition is just going to fix problems tomorrow, whether leadership is going to change every couple of years, whether we can count on the change from one tech era to the next to lead to a change in leadership, or whether things like mergers might be used to maintain leadership across shifts and not see those changes that we might have hoped for. We're going to see patterns in how things are entrenched. So I might write a theory that says, here's some way that theoretically you could entrench through a merger. But then if we see it happening over and not getting corrected by the market over 15 years, that informs our analysis. And then we see more empirical work, like in the case of labor. We've already seen since the 90s, and there was recently a Nobel Prize from folks who did things like measure effects of the minimum wage, and that really got folks to take quite seriously that labor markets might not be competitive. It was pretty hard to reconcile their work with things being perfectly competitive. But we've gotten more and more empirical work and more evidence, and along the way we learn how to measure, and we get better frameworks for understanding that. So those are really, I'm really excited today. We're going to be digging into those areas. Let me now talk about a few of the really important areas that we've made, sometimes subtle, but in my view, important changes. One is about risk assessment. So the statute talks about a risk. Its effect may be substantially to lessen competition. And we have re-elevated the risk assessment part in a way that I think makes it much easier to bring honest economic evidence to the table and evidence that hits on your most important concerns. So why does that matter? Well, if we say that competition is that to measure competition, we must quantify the prices. And to be clear, 2010 guidelines didn't say exactly that, but it ended up being used in that way. So it's not, I don't think it's the drafter's fault that it came that way, but ex post, when you go back and read it, you can sort of see how it evolved in that direction. That market power was essentially defined as something that a merger can lessen some competition by making it possible for firms to increase prices or reduce quality, but focusing on prices. And so if you think there's going to be a merger, an entrenchment, something where the effect is going to be lowered investment and innovation, not making the products as consumer friendly, things that are harder to quantify, less firms, less platform participants enter the market, or they don't get funding because they might get squashed later by the platform. Those types of concerns are harder to put a number on. It's hard to write down the structural model and write out the equilibrium of exactly how many firms are not going to enter in the future and so on. That's very difficult. So then it leads us to think about making those cases and then backing away because we feel like we can't take them across the finish line. And then you focus your energy on the things that you can quantify. But then you end up with a story where the Economist's evidence doesn't actually match the reality of what's happening. It doesn't match what's in the business documents. It doesn't match the true motivations for the mergers. And so you have this disconnect. And I think that's one reason people got frustrated with the Economist. But I would say it's not that the Economist wanted to ignore the economics. IO theory thinks about all of these things. It's that we kind of felt difficulty meeting this artificial bar. But if you think about this more from a risk assessment exercise, so I have an economic framework that tells me the nature of the risks, but I can use lots of different evidence, qualitative evidence from the way that the parties thought about these mergers, and so on. then it's easier to bring in the full range of evidence that really convinces you that this risk is real. So it's not that the economic framework is necessarily different, it's that we just don't require certainty, and then we allow ourselves to tell the true story, and instead of telling a more limited story that doesn't really match the facts. So, this is some of the language in the guidelines that, we're talking about, not necessarily predicting these effects with certainty. On the rebuttal side, I've got some text here from the draft guidelines that, talks about, first of all, at the beginning of the rebuttal section, there's a very kind of open-ended quote that talks about, how there's generally, we're going to look at evidence that this merger does not threaten to harm competition. There's a bit of an asymmetry because the statute is saying there's a risk. And so to rebut it, you want to say, no, I don't think there's a risk. So it's not completely symmetric in how you think about it. The harm could come in many different ways. It could be unilateral effects. It could be coordinated effects. There could be a future innovation story, but to rebut it, you would need to say, well, not only is this an industry where, I don't know, there's scale economies, and so people are competing very hard in the short run, even with a small number of firms, to make sure that they don't lose their network effects to keep people on the platform. So this is a reason that I think that things will continue being competitive. But also, you need to explain to me why these firms aren't going to be able to coordinate in some way, or why if you have 2 or 3 firms selling an important product, why they're not going to sort of divide the market, why they're not going to one of them go downscale, the other one upscale and soften competition, and why, if the barriers to entry are so high, these small number of firms aren't going to find a way to reduce innovation or just lighten up on one another. So that would be, so on the one hand, this is very open-ended. It says if you can show that this does not threaten to harm competition, if the scale economies and network effects are such that these merger of 6 to 5, these small platforms, actually that merger is going to increase competition in the market. It's going to offer consumers more alternatives. It's going to give people more meaningful choice because maybe those small platforms weren't providing them enough people on the other side of the market. They weren't really a meaningful choice. That could be an evidence that this merger doesn't threaten to harm competition. But the rebuttal would really need to engage in the fact that with a small number of firms, there's lots of ways that competition can be harmed. And what are the special circumstances that make this work? So, the rebuttal section, in some sense, it's very familiar. It's got the familiar elements, specificity, verifiability. We do talk through this idea of pass through to competition. So again, I don't care if your costs go down. What I care about is that because your costs go down, you're a more effective competitor to the other folks in the market, and that therefore the customers in that market will have better choices and so on. And so that concept of why we care about efficiencies is important. It has to make you confident that this merger doesn't violate the law, that this merger does not create a risk of harm to competition. So now let me kind of get a little bit more into the meat of the analysis here with platforms. And I want to set up a couple of the concepts. And some of these concepts could have been articulated inside a platform section because they are so core. Platforms often have scale economies and they often have a lot of concentration. So entrenchment concerns are very frequently part of any kind of platform merger evaluation. But a lot of them also can apply to single-sided markets. And so they're going to hit multiple angles. So first of all, what do we talk about in these 2010 guidelines, in the 2023 draft merger guidelines? We talk about how this entrenchment doctrine properly blocks artificial competitive disadvantages, but not simple improvements in efficiency. So one of the pieces of feedback that we got despite the fact that this was sort of in the opening paragraph and in the closing paragraph, and is that folks were concerned that we had not fully delineated the difference between a merger that, you know, improves the quality of products and one that's anti-competitive. And I'm sympathetic to why this is challenging, because in markets where there are network effects, if you make your product better, you're going to get more customers. And so that does make it hard for rivals to compete with you. But the examples that we gave of, you know, things that were anti-competitive, and I'll give some in a few moments, are things that are artificial, create artificial barriers to competition, things like increasing switching costs, things like making it difficult for firms to compare price, for customers to compare prices, and so on. Now, entrenchment can be used for horizontal or non-horizontal mergers. Another piece of feedback we got was, well, for horizontal mergers, why do you need an entrenchment guideline? You have guidelines that talk about the problems of concentration. And so if you have a horizontal merger and a dominant firm, aren't you already going to trigger the thresholds for horizontal mergers? And I think there's a couple of responses. One is that that when you can actually directly see a firm exerting market power, a dominant firm in an industry, that sort of helps you understand the risk assessment framework here. It says these barriers to entry that I'm pointing to, they're real. They've been operating, they've been affecting outcomes. And it can point, starting from the source of the market power, can help us analyze the merger. Another question is, you know, how do we think about what our good policy is? If we're not sure, should we just let the merger happen and bring a conduct case later? So if we're worried that they might bundle or do something else that's going to raise barriers to entry, well, we have laws that prevent entrenchment. We have laws about monopoly maintenance. Why don't we just do that later? And I think that's an important policy question, because in the US, that doesn't happen very often. Those are very difficult cases to win. We don't have much of a framework we don't have very good case law to bring those kinds of cases. And well, the merger approach is prophylactic. And afterwards, you're trying to unwind something that's a much harder thing. So we're worried about that risk. The merger is a great time to address that risk. We also have multiple legal frameworks that can apply even to a merger. The Sherman Act also can apply to a merger. A merger can violate the Sherman Act when it's reasonably capable of contributing significantly to a defendant's continued market power. So that is where monopoly power, sorry, is the word that's used there. So that monopoly power, again, if we can establish the market monopoly power and see that evidence, then the Sherman Act can come into play. And that just gets us started in a different perspective. Now, for another issue around that is that, well, for non-horizontal mergers, it's even trickier under the existing case law. And so this type of Sherman Act framework might be much more practical. And so I had an example on here. We don't have a lot of these types of Sherman Act types of cases that we've brought. There was an abandoned merger between Visa and Plaid that kind of fell under this type of an analytic framework. So when you think about what we had to work with here from the previous guidelines, the 2010 guidelines did not give us a lot to build on when it comes to entrenchment. So the 2010 guidelines did not define levels of market power. There's been a lot of discussion about what we should do, including from folks who want us to be more like the 2010 guidelines. But there's no way to be like the 2010 guidelines on entrenchment, because the 2010 guidelines just don't engage with it. So the 2010 guidelines basically said, okay, their unifying theme was mergers should not create, enhance, or entrench market power. But then market power is defined only by an increase in market power. And an increase in market power is something that allows you to raise price. So And then even like in the unilateral effects section, they don't even use market power. They use basically increasing prices. It's all about the effects on things like prices. And they do talk about quality, but I'm just going to use prices as a shorthand here. So they circumvented the need to say what is a level of market power. And of course, that I understand why economists want to do that, because from an economic textbook perspective, there's a perfect competition benchmark with zero market power, but the real world, there's always some market power. So the idea that there's some threshold where there is or isn't market power doesn't even make analytic sense. So economists are much more comfortable talking about increases in market power than about levels of market power. But if you want to talk about entrenchment, we have to talk something about a level of market power, and that's just not in there. They do have one example in the 2010 guidelines, which is an example of entrenchment, but it's not really introduced as a framework. So that left us open, and that's why getting the comments here has been so helpful. What was in the 2023 draft merger guidelines that were put out was a 30% threshold with a sliding scale towards more market power is more of a concern. A lot of people saw the 30% only and didn't necessarily read to the sliding scale part, and that's been made that part gotten a lot of attention and a lot of feedback. So that's something we're thinking a lot about is, well, if we're really mostly going to bring this case in a case of extreme market power, then maybe it's fine to engage more fully with just a higher threshold. So your feedback on that is very important. So what are the economic concerns? Emerging firms starts with market power. And I think, again, that's going to affect the risk assessment framework. We have seen entry hasn't fixed the problem in the past. So why do we think entry is going to fix the problem in the future? We can argue about whether switching costs are high or low, or whether a consumer theoretically could do 3 clicks and get there. But if whatever that is hasn't constrained the ability to exercise market power for a long time, and if you look out in the industry and say, oh, are people funding new entrants left and right that are successfully constraining this? If that hasn't been happening, then that gives more credibility to your argument that the barriers to entry here are real. We also can really need to think about this in the context of non-horizontal mergers. That's just been a very difficult type of case to bring and win. The case law is challenging, even though we can look out and see lots of examples in the past 20 years where that appears to most reasonable economists to have happened, to have been a problem. And so there's a real challenge with the analytic frameworks. But from an entrenchment perspective, if you say, here's a firm that has market power, we already are worried about risk, and now they're buying something that might be a multi-homing tool, that might be something that affects switching costs, then that framework may be more helpful. Another thing that we talk about in this draft guideline that's very applicable to platforms are nascent competitive threats. So from the perspective of a two-sided market where there's a chicken and egg problem, and it's difficult to find out how to enter, there are very few paths into this. I teach business school classes about that. Everybody wants to build a platform. They look really awesome. They make lots of money when they succeed. But now, how could a student ever build a new platform that would enter in the face of chicken and egg problems? More buyers, more sellers, more sellers, more buyers. There's a few tried and true approaches. One is that you somehow get customers on one side of the market, and frankly, you usually are buying them in some way. You're getting a distribution deal, or you own something that gives you unique access to a set of customers. You enter on one side of the market, create a really great value proposition on one side, and then you become a platform on the other side. From a merger perspective, then, you might see a two-sided platform buying someone who's succeeding really well on one side. But if you could buy everybody who ever met needs on only one side of the market, you would never have entry. That entire entry path would always fail if the platform had a carte blanche to buy anybody who provided value proposition on one side of the market. So this nascent competitive threats idea is very, very important for platforms. And it means that the entrant, it's in the market in the sense that it's producing a product, so it's real, but it's not producing exactly the same product as the platform. Nonetheless, that is a key entry strategy. The other main way an entrant can overcome the chicken and egg problem is they enter in a niche. There's a general purpose platform that's pretty good for everything, but they're not that good at one particular segment. that needs better, different kinds of reviews, different kinds of information. Maybe it needs more quality screening because quality is super important in that particular segment. It needs more trust and safety. So maybe it needs different kinds of payments. There's different types of things that are needed for there. And so somebody gets really good in that niche. But again, once they acquire consumers, they can start marching sideways to compete with the platform. So they're not constraining the platform, the big platforms pricing today, but in the future they could. And again, if a big platform could always buy every niche platform, and they could always buy everybody on one side of the market, my personal prediction would be you're not going to get a lot of new entry in this market. So we really need to understand the nature, the economic theory behind entry and nascent competitive threats, and then be on the lookout for those types of mergers. And again, I think this whole argument becomes easier to make in the framework of entrenchment, although it can be made outside of that framework as well. So we give some examples, and I think this is something where I think people wanted more examples in the comments. So some of the examples we talked about, though, were tools for porting or syncing data. So if a new platform is going to enter and overcome the chicken and egg problem, another thing is if it's very easy for people to keep using that big platform who has access to more buyers and more sellers, but they can also use an additional platform in those specific cases where that other platform does actually have some unique value or lower prices. So then making it very easy to flexibly multi-home will be very important. So you might see a firm come up that is great at price comparison or great at porting your data, great at helping you multi-home. And then the platforms are like, oh my goodness, that's making it easier. That's going to reduce switching costs. So I want to buy them. And yes, they're a complement to my platform. So it might look like from a short-term perspective that this is a firm buying a complement. It's also a complement to your competitor, and it's also a complement to competition. And of course, the main platform doesn't care about the value people are getting on other platforms. It doesn't want people to get value on those other platforms. And so they're not internalizing the externalities created. And that's something that Fiona Scott Morton and I fleshed out in some detail in our platform annexation paper. Seemed to be a big source of confusion. There's like a kind of a traditional neoclassical argument that says, if you buy a complement, that's going to be good. And you have to say, where is the externality? What is the thing that this platform isn't going to internalize? And the thing is, the main thing this tool is good for is for increasing competition and lowering markups and lowering market power today and tomorrow. Then, of course, their incentives, the incentive to compete aggressively is very misaligned with overall welfare and competitive outcomes. Another example would be a firm that does a lot of bundling, and that could be a form of entrenchment. Again, we're not necessarily going to go, it might be difficult to prosecute the firm directly for its bundling, but if you see bundling as a tactic through which you would increase barriers to entry through the merger, that's going to lessen competition. That might be that might be a key moment where you could address with it. Finally, like coming to the particular concepts associated with platforms. So first of all, again, this brings in concepts from multiple guidelines. We did get the feedback, why do you need this? But at the same time, we have so much feedback within there. I think that sometimes the same comments say you don't even need this, but then when you get into it, they're debating about issues that people disagree with in the middle of platforms. I think that's sort of evidence of why you do need it, because let's at least get the framework that we're arguing down, and then we can move forward from there in our cases. So there can be horizontal concerns, there can be potential competition concerns, raising rivals cost, entrenchment, also serial acquisitions, and trend towards concentration as well. So another piece of feedback I haven't talked as much about yet for platforms is, okay, we can put out the economic logic of where the problems are, but how is an investigative team or a judge going to distinguish harmful mergers from mergers that are not harmful? And if stating the prospective theory is challenging, stating where having a clear delineation of where there isn't a problem is even more challenging, because there are so many different mechanisms through which competition can be harmed. But certainly would continue to value feedback people have about how to draw those lines, a rubric of looking how clearly have you stated the case of harm, one way to look at it is, well, can you also figure out from the harm how you would make a case that there isn't harm? And I think that's easier for some theories than others. I think this is one of the ones where it's very challenging to sort of look at it from the other perspective. Nonetheless, that is in the end, if you have a concentrated industry and a platform is trying to buy something that's going to affect platform competition, that burden, can go to the defendants, and they will need to think about all the different ways that this merger could harm competition. One other piece of feedback, sorry, that we got was the term. There's a few loaded terms. So conflict of interest. So I'll talk about how I saw that being defined in the draft merger guidelines, but we got a lot of feedback about that term. And so that creates the opportunity to further clarify, how does the term conflict of interest fit into the economic frameworks we've laid out in these guidelines? So the key economic frameworks that we talk about in platforms are competition between platforms, and that's going to be, the horizontal competition we talked about. We're going to understand these common entry strategies, like entering in a niche or entering on one side. We're also going to recognize that tools that facilitate switching or multi-homing will affect horizontal competition. We might also think about inputs such as data affecting horizontal competition between platforms. And it's been commonly said, a lot of vertical issues are actually horizontal issues in disguise. That you might be buying a non-horizontal competitor, but the theory of harm is how it's going to affect horizontal competition between the platforms. Competition on the platforms. So a conflict of interest might affect competition among platform participants. And so there's a few key economic concepts here. If competition doesn't work as well, say among sellers on a platform, that's going to affect competition on this platform, but potentially also competition on other platforms. So if the number of firms gets reduced because on this platform one of the firms is preferenced and there are scale economies, that might lead to a weakening of their rivals, which is going to affect outcomes on this platform, but also on some other platform, which might not want to prioritize in the same way the platform-owned seller. So if the main platform buys a seller and owns that seller, and that's an important seller, that's going to make things worse on the other platform, especially if you're worried in the future about exclusive access or preferential access to the seller. So the other platform needs the seller too, or it needs a similar seller. But if we only end up with one good seller and it's owned by one of the platforms, that's obviously going to make the customer experience worse on the other platform, and that's going to feed back into the horizontal competition. So again, we talk about this in the platform annexation paper, but there are clear externalities here. There are good reasons why the dominant platform's incentive to maximize their profits is also going to reduce competition in between platforms, but we may need to flesh that out more. We finally talk about competition to displace the platforms or services. Opportunities might arise during tech shifts, and also there may be non-platform services that lessen dependence on the platforms. Like if there's really good payment options, if there's really good reputation options, there's other really good technical services that could be provided by a platform, but they could also be provided independently. That can create a toehold for future competition. So summarizing, those are the key frameworks. I hope that my task here was to sort of set up the whole conference as well as the platform section. I've hopefully highlighted a bunch of areas where the comments so far have been really helpful and really focused us in on where we needed to clarify. And I'm really looking forward to learning more today, and maybe some, of course, new comments or additional comments that I didn't have time to forecast. Thanks.
I'll just talk to the panelists for a second. So Susan covered a lot of ground, and I've been looking at your academic research, and I'm going to pose some questions to you from things that you've written. But there's a lot of ground here, so feel free to bring up anything you want. Okay, so you're not constrained. So to start things off, let me pose a question to Rebecca to start out. And Rebecca, I know that you've been writing and thinking about the consumer welfare standard. So my question is, what is your view generally about the draft merger guidelines implicit treatment of the consumer welfare standard? And specifically, do you think that the treatment of mergers involving seller side market power in any way vindicate the merger guidelines on that topic?
Yeah, thank you. So, I think it's easy to look at this moment that we're all in as kind of a battle over the soul of antitrust, right? What is antitrust for? Maybe up until 5 years ago, we thought we had a consensus view that antitrust is for consumers, for something called consumer welfare that somehow turned into something called the consumer welfare standard. That I think is a mistake that I'll get into it for a second. But the idea that that antitrust is for consumers now has a viable rival. There's we'll call them Brandeisian, we'll call them New School, we won't call them hipsters, saying that it's actually about so much more than that. It's about democracy, it's about little guy competitors, it's about consumers as well, but has all these other potentially competing goals. And so the Brandeisian, the New School takes over the agencies, okay, and then they come out with the guidelines. And the guidelines are the most prominent and important opportunity that the agencies have to state antitrust policy generally. And so I want to first of all take this whole discussion kind of outside of mergers for a second and just say that this is a statement of the DOJ and the FTC's policy on competition. And so the question arises, does this document do away with the consumer welfare standard or consumer welfare as a goal of antitrust policy? And my view is that it does not. It does not. And I think that there's probably people in this room who would lament that. I don't. I think that actually that markets and competition being good for consumers is an important focusing point for antitrust law. But the big change that it makes, and a change that we badly needed, was to change the time frame on consumer harm, to change the conversation from consumers today, next week, to consumers of the future. Now, the one sign you might have that this document does away with the consumer welfare paradigm is that it seems to replace that phrase with substantially lessens competition. It seems to move the analysis from consumers to this idea of competition. But if we really closely look at what the guidelines say, you'll see that every move made, and in fact, every move that Susan made in her very nice introduction and overview of the guidelines is about the health of a market for the purpose of consumers today or tomorrow. So for example, I'm actually not going to focus so much on guideline 10 for the same reason that Susan brought up, which is that it is, so I don't have a problem with having a guideline 10. I actually think it sort of is a nice move. It's not redundant, but it is the things in there are addressed in the rest of the guidelines. So for example, guideline 4 talks about a potential entrant. This is a dynamic view of how the market might or might not vindicate consumer welfare. If this entrant were allowed to come in, the market might look better and more competitive down the line for the benefit of consumers. I think when I read that about the Facebook Instagram merger and how under the guidelines proposed here, that merger would have been looked at differently than the 2010 kind of obsession with horizontality. Is Instagram in that market right now? Are they selling the same product to the same consumers? No. Well, then I don't see how they're going to raise price next week. But it is easy to see now that Instagram was a strategic and long-term threat to what Facebook had. And that is why they acquired it. So guideline 4, potential entrant, is, I think, ultimately about consumers. Guideline 5, control over inputs, basically. So we don't want to have a merger necessarily where you're going to start to have control over inputs to a product that might allow you to raise rivals' costs. This again is a dynamic view of what's going to happen strategically down the line, not even necessarily in the particularly distant future. We move a little bit further into the future when we get to guideline 6, guideline 7. Both of these I see as guidelines about non-horizontal mergers. And in particular, these mergers are really focused on, I might even say the whole document is obsessed with entry, something that even Bork himself said was a very important consideration. Never mind that the old paradigm never really looked realistically at how entry actually happens. And that's one of the things I really liked about Susan's talk about saying, well, this is how you become a platform. You enter one side first. And so by making these kind of horizontal or these vertical or non-horizontal mergers more suspect under the guidelines, we are creating a longer term, healthier potential for entry, and therefore more horizontal competition, which benefits consumers. I think here of the meta within merger, where that's not horizontal exactly, but as we know, Meta is in the process of building an ecosystem. I mean, it is an ecosystem, it has built an ecosystem, but of entrenching that ecosystem. The way you do that is by creating other properties that then create so the guidelines kind of, one small little detail I would say here is they talk about 2-stage entry being a problem. I would call this the dual entry problem. But of course, it's not a dual entry problem. It's a 100 entry problem. When you have an entity like Meta is not as close of an example, but Google, for example, that has so many properties to really truly compete with a Google, you've got to, in fact, this came up in the case this week. You have to have so many different products to actually enter as a head-to-head rival against Google. It's almost impossible. So every non-horizontal merger potentially creates that risk. We need guidelines that are realistic about how head-to-head competition, and this is another thing that Susan said that I think is so interesting. And I will point out, a bit at odds with the rhetoric that we have heard from the Brandeisians so far. But you'll notice that Susan kept bringing it back to that horizontality. She kept bringing it back to how, I think she said, it's vertical shenanigans. She didn't say shenanigans. Disguised as verticality, but the underlying problem is really horizontal. Okay, and yeah, so I see the guideline 7 about entrenched dominance as a long-term commitment to making toppling more possible, toppling of these big platforms more possible. It talks about things that would, again, prevent entry, increasing switching costs. Talks about nascent competition. All of these are a more long-term dynamic view of how to vindicate consumer welfare. And I think that's I think what's really kind of striking. There's no discussion of democracy. There's no discussion of little guy competitors. There's really nothing even about size, other than what we already had from the 2010 situation. There's these 2 first guidelines that I think basically largely track the 2010 points about concentration, brings the numbers back down to 1982. Am I right about that? Changes the presumptions, but like same idea that, you could do this HHI and you can figure out concentration. So, okay, but here's where maybe I want to get a little bit critical. As you can tell, I really like the guidelines. In fact, next week I'm supposed to give feedback. Like it's more like here's how you should fix the guidelines. I'm kind of struggling with what to say. They're not that well written. They're a little confusing and like a little bob and weave going on. But I think that's kind of an editing problem more than like a substance problem. But here's where I do run into some problems. This idea of prioritizing long-term consumer welfare, which I think we should be doing, and I think it's an important corrective against what we were doing, has trade-offs. And in conversations with people in government, more so than in the document, I get the sense that they're kind of repeating the mistake of the Borkism by saying, we don't have to make any trade-offs. There's nothing to be traded off here. Consumers are better off in the short term and the long term by everything that we do now. Now, Bork, and I'm using him as an avatar for the whole set of ideas, said, we don't have to make any trade-offs. We don't have to make any difficult value decisions. It's all math. It's all science. I'll show you the graphs. It was static equilibrium. It was, it was actually trading off a lot of important things that we're sorry we gave away now 40 years later. But there are problems with prioritizing long-term consumer welfare that the guidelines maybe, or at least in other settings, we should be honest about. One is that it's going to increase the speculativeness of these decisions. I don't see this as fatal, but we should not be afraid of saying it is hard to predict dynamic competition. It is not something we can say with certainty. And there's going to be risks that we're going to get it wrong. Okay, and the other thing that I think is maybe even harder for the agencies to say is that this may sacrifice short-term consumer welfare. There may be a world in which you want Call of Duty on your phone right now, and this merger gives you Call of Duty on, it's not on your phone. I don't know how people play these games. But next week, all of a sudden, Microsoft is going to have Call of Duty, and everybody who has Xbox, now I'm getting it. Okay, everybody who has Xbox is going to have Call of Duty output expanding. That's great. Okay, well, that's not the way to think about it, I think, but it does mean that it might be harder if we're going to block a merger like that, thinking about the long-term chess game, thinking about the consumer welfare down the line, thinking about the ecosystem, the what do you call it? The cloud gaming, that we're going to have to break some eggs to make this omelet. And I would love to see a more robust discussion of how to trade off that uncertainty, how to trade off the future with the present consumers, and not pretend, as maybe you need to do in sort of a political economy setting, that you don't have to break any eggs. Another one controversial to say, I think, is that these policies destabilize entrenched monopolies, which I think is great. It also makes obtaining that monopoly less valuable. So Trinco goes way too far. Trinco says, the best thing about monopolies is that you can screw over consumers forever, and that's the only reason we're going to get people to build networks. That certainly does go too far. But I haven't seen a lot of great theory about where is the point of too much is too much, right? Like, we don't need a monopoly like Google to last for years and years to create an incentive to create the Google. But can we think and talk about what kinds of value propositions we give to platforms in order to incentivize the cost of creating the platform in the first place? I think that's, I could go on a ton to say, but that was kind of what I had in mind to answer that question.
Well, Susan, what happened to the small guy and democracy? On the first page of the guidelines, it cites to Congress when they revised the Clayton Act, and that was two of their most important goals.
So I think I'm gonna violate what was just said about not wanting to acknowledge trade-offs. But I think in many cases the benefits of competition are aligned with all of these benefits. So I guess I think that I think we have come up with a framework that is going to be beneficial for democracy and the small guy, but it's also operational in terms of the antitrust frameworks that we have. I guess I just want to maybe while I have the floor, I wanted to come back to one of Rebecca's lovely points here at the end about breaking some eggs to make the omelet, because I think these things are related. Where are there actual trade-offs? I think this is a really big issue with platforms. I think I'm just going to restate what you already said. But if one platform has good scale economies, it has lots of buyers and lots of sellers, if you ask any particular customer and say, why are you using this platform? They'll say, well, this platform gives me more sellers, or this platform gives me a better value proposition. And that's true. And that's exactly, so we generally want to listen to our customers, right? But our customers themselves may not understand that, first of all, the benefits they're getting today may not last forever if there's no incentive to innovate in the future. Like, they're enjoying the benefits of past innovation, but what about future innovation? And if there's no competition, why do you think it's going to keep going? And we've seen lots of monopolists degrade over time when they didn't have to innovate, despite how they all said innovation was their DNA. And then a second element of that is then, there beyond the innovation is just that why, like, they could have even more welfare, they could have even lower prices if they had a stronger competitor. But that requires both the judge and the customers to understand the equilibrium. And it's hard because even economists get confused about this equilibrium, and I think even smart economists and smart antitrust lawyers, their brains are so wired for the short term that they've forgotten how to do the actual economic analysis, which includes the equilibrium and the long term. But I agree with you that it is really scary. I think I'm speaking more in my past work as doing expert work, but I think it's generally true. It is really scary to think about going into court or even going in to present to an agency and actually saying, if you break this egg, like there will be a period of time while competition is restoring itself where some things could go backwards. That is terrifying. But that doesn't mean that that our answer is to let entrenched monopolists last forever, because we won't bear any of that through. So I just want to acknowledge that that's a concern, but I don't know how to fix it within the system that we have. So one way to think about it is you have prosecutorial discretion, but you're going to not give yourself the burden of doing all of that. That if we find one kind of harm to competition, that can make our case, and then the parties need to explain why it's not a problem.
Just Nancy.
Can I weigh in on that? So I'm a little less concerned about that tension in the context of mergers. And that's because companies have a choice between acquiring this other company that is leading to these kind of competitive concerns and developing that capability or that market or those customers or whatever organically. And I guess I always had this sense in thinking about this from an enforcement standpoint that particularly in sectors where barriers to entry might be substantial, and I would think that's, especially true as we've been discussing, where there are strong network effects and there's a dominant platform already, that the structural change that's wrought by a merger, we could think of as, if not permanent, at least very long lasting. And so if we don't take the opportunity of blocking a merger that we think is going to entrench the monopoly platform or the dominant platform, or enhance the moats around it, or prevent them from acquiring a competitor that could disintermediate or disrupt the platform in some way, then we've lost that opportunity for both short run potentially and long run gain. And so I guess, I think recognizing that mergers are different than organic growth, and that even if we eliminate a merger, we're not eliminating the possibility for the platform to do the same thing organically, maybe should give us a little bit more comfort. That said, I think Susan's identified a critical challenge in this area, which is, as much as economists and lawyers, at least of a certain persuasion with respect to enforcement, might agree that something's desirable, convincing a federal district court judge, or perhaps even more, the circuit court or this Supreme Court, that adopting standards that feel less quantitative or rigorous, or to go to Rebecca's point, kind of, Susan, I remember who said speculative, like to embrace those cases may be extraordinarily difficult. And I think the goal of the guidelines is to help provide some of that comfort, but maybe guideline 10 could do a little bit more in its discussion of how to evaluate these, or to kind of make it more clear that the type of evidence is going to be, not what judges are used to seeing when it's a commodity product merger between two existing companies in kind of the old economy.
Andrea, didn't you give a 2020 speech about breaking eggs and the long run?
I think if you think about regulation in a number of industries with network effects, historically, we have had in place rules that were essentially reducing short-term efficiencies for the benefit of dynamic efficiency. So I think in many ways, what the guidelines are trying to do here in mergers is nothing new, and essentially is really trying to correct mistakes from the past. I mean, on the consumer welfare point, I agree with Rebecca. I mean, in a sense, coming from Europe, this is a very US-centric discussion because, in a sense, both the UK agencies and the EC have always interpreted consumer welfare with a longer time frame. So I think in many ways the guidelines again are quite correctly trying to fix a mistake, which was for whatever institutional reason too much focus ended up with short-term pricing, with quantification. So if I look at my experience in the CMA and the experience of the European Commission, it's always been accepted that merger control was about prices, output, innovation, quality, and in many ways was much more about the medium term rather than the short term. And that has been accepted by judges in Europe in multiple cases. I mean, obviously, I think that is a benefit of an administrative system as opposed to the system you have here. I also agree with Rebecca that there is a limit on how much you can, I think, helpfully include in the consumer welfare. So, for instance, questions about democracy, I think it's just stretching the test too much. So, for instance, in the UK on merger control, we have public interest test on very specific matters, including media plurality. And that essentially is an extra layer that Parliament included. So essentially, if there is let's say, an acquisition of a newspaper or some media property, essentially we have two parallel exercises. One, which is very much consumer welfare competition one, which will be looking at advertising, etc. But then you have a separate media plurality one, which essentially is more stringent in a number of cases, might drive to a prohibition where you wouldn't get the prohibition on the consumer welfare stand. But I think it's clearer to have that way. And in many ways, if I look historically, the UK essentially had a public interest test for mergers until the end of the 90s, which included essentially everything. And the view was that it was just too complicated. There was lack of clarity. So then the pendulum swung very far into consumer welfare. And I think if you look at the 2010s, probably the UK had similar issues to here. It became too narrow, too short term. And essentially now there's both an exercise we did on the merger guidelines in 2021, which is quite consistent with what's happening here, plus the public interest. Now there are additional aspects that are being included, again, to try to find that kind of sweet spot where you have both. And I think in many ways it's really learning from experience and realizing consumer welfare, it was just too narrow at the end of the day for merger control.
Well, maybe, can I just challenge Andrea just for a second? Because you wrote a paper called Resilience and Competition Policy. Yes. And in the paper, what you argue is that, look, there are these mergers that, well, there's a reduction in competition because there is a merger, but the harm is not coming through price and output. It's coming through other mechanisms. For instance, bank mergers that lead to too big to fail. You mentioned in your paper the audit industry in the UK. And it leads to lack of transparency among corporations. Media mergers can harm democracy. So aren't you arguing there pretty much that the old consumer welfare story about price, output, and innovation is too narrow?
Yeah, so I mean, what we did there with that paper was essentially to react a bit to the experience during COVID and the problems with the supply chain. And I think, Jonathan Cantor, for instance, given speeches along very similar lines, which is, in many ways, if you go back and look in time to merger control, probably during the 2000s and 2010s, there was almost a sense that you were trying to optimize for, let's say, a normal external situation. So you were kind of assuming that, everything was fine. We are now optimizing. We think, we have 4 firms, 5 firms. This is the right equilibrium to generate the right outcome in this sector. And again, I think experience has shown that it was a bit too narrow because suddenly COVID happened, wars happened. And audit, I think, is a great example. Late 90s, Pricewaterhouse and Coopers and Lybrand get together. It's a 6-to-5 merger. The agencies correctly recognize that the barriers to entry are colossal and expansion in this sector. But they think, we're smart, we're doing the analysis, 5 is a good number. And then, Enron and Arthur Andersen happened. Clearly, no one had thought about it. Suddenly, you're down to 4. We spent a whole year trying to work out how we can increase competition in that sector through one of our authorities, which is a market study. And I was talking to some of the other agency heads, very similar problems in Germany, in the US. Very, very hard to create now a fifth or sixth serious competitor there. So 20 plus years, a bit what Nancy was saying. There's a major structural change in the market. And, ex post, the analysis wasn't sufficient because it missed the idea that suddenly you need some redundancy in these markets. You can't just optimize. And so I think then, so that paper was really to try to bring it in as part of the discussions. Then pragmatically, I think the question is whether you say this is a part of the consumer welfare. So we're going to potentially challenge a merger that doesn't create this redundancy and essentially deal with the judges the same way as the agencies here have to deal potentially with quite skeptical judges on this point, or whether we talk to our government and parliament and say, okay, as public interest test, we're going to add an extra aspect, which is potential redundancy, which will be a cleaner way potentially to allow that consideration. So that is still very much in play in the UK. But I think the general point that consumer welfare needs to be for the medium term and a number of scenarios, I think is a very, very valid one.
Susan?
So many excellent points have been made here. I just wanted to come back actually to connect the innovation points and also the little guy points here. I think I get a little frustrated when people talk about innovation without being a little bit more precise and whose innovation and how much what kind of innovation. Generally, if you have a successful platform, there are lots of ways to make money. Microsoft Windows in the 90s didn't even have the technology to charge app developers or to charge consumers for using their platforms. They still figured out how to make money. They charged in a different way. And if you look out and you think about all the different platforms that are popular right now and what are all the different ways they have found to profit from being a large successful platform, they are very many. And I guess I'm just not that worried about there being not enough incentive. Like to really have not enough incentive to innovate, you need a lot of things to be true from the platform perspective. On the other hand, think about the little guy, you have small businesses, whether it's, digital app creators, whether it's regular old businesses who now need to reach their customers digitally, whether it's people who need to get payments. And if you don't think that charging 1% more or 5% more affects like every single participant in the economy who has to pay those fees, I mean, that's just kind of nuts. And it's affecting so many more entities' incentives, and it's affecting a lot more folks who are on the margin of being in or out. I don't think most of these major platforms are on the margin of being in or out, or of having a team that makes their user experience better or whatever. Like they are so far away from not having that be profitable to some degree of doing that type of innovation. The main thing that they need is more incentives to innovate in a way that's friendly to their consumers. But there are lots and lots of small businesses that are operating on margins thin enough that if you go from a 1% tax on them to a 2% tax, or from a 5 to a 10, or from a 25 to a 30, that's if there's millions of these businesses, there's a big chunk of them that are right there where that's there. And we had this conversation decades ago talking about kill zones, talking about different types of acquisitions that would make venture capitalists not invest in entire sectors. And that continues. I have a lot of interaction with Silicon Valley ecosystem. And when they are looking at, the cost of acquiring a customer versus the long-term value, they're looking at all the inputs into that cost of acquiring a customer. And, it's a small change in taxes there, if you like, has a big impact on what gets funded. So,
Yeah, but what they say is that if you stop mergers of nascent competitors, that the VC money will dry up and you won't have any innovation.
So there are different stages of the innovation pipeline. It is true that you need some fancy prize at the end of the day to get them to invest, but you also need the marginal economics to work out. And, people will complain publicly about the exit opportunities, but privately they're in the room running the numbers. And I promise you, those customer acquisition costs are in every single deal model, and they are in every single subsequent finance raise. And especially for firms, once they've gotten initial funding and they're trying to raise additional capital, every single VC wants to know how you're acquiring customers and what you're going to have to pay to get them. So that's just that's just, different. Again, I think it's an intellectually lazy frame to only look at one part of the funding cycle and to think about that. And if we think from a social perspective, do we need the benefit of this firm to the monopolist to be the thing that sets the price, the innovation incentives, or would it be enough to have a competitor or an entrant be willing to pay for that delta between the thing that where the innovation incentive is incorporating the future monopoly profits versus the overall welfare created for the industry? I'm happy maybe to take a little bit of a haircut on the piece of it that's just due to entrenching the dominant firm's monopolist. And I think there's actually like plenty of folks out there that are still willing to pay for an exit.
Nancy, you're shaking your head. Do you agree?
Yeah, so I want to make a distinction here because I largely agree with everything that Susan said. I think one of the things that concerns me in these guidelines is that you could read them to say that for small innovators in some markets, particularly in markets where they might be producing products that are, let's just say, relevant to a platform, but not even just platforms. This is also true in the just for non-platform firms as well, when we're thinking about kind of at least how I read the kind of entrenchment story. I think there's this tension, and while many people in this room might want to just would happily ban all mergers or most mergers, particularly by large firms, whether they're large market share or just large firms, and while I tend not to think that most mergers are motivated by enormous social efficiencies, I'm not confident enough to say that none are. And let me give you an example of something that I worry a bit about, not so much in the platform space, because I can't speak as authoritatively as Susan can to the Silicon Valley space, but I think the same kind of argument arises there. So I think about the kind of biotech pharma space, where many of my MIT colleagues come up with some insight in terms of, a possible mechanism to treat disease, say, and start a little company in Kendall Square that tries to take that insight into a potentially viable pharmaceutical product. But they don't have the capacity, if that turns out to, the early stage research turns out to be successful, to commercialize that. And so the typical exit strategy for those companies is to sell to a company like a big pharma company that has the capacity, the capital, both physical and intellectual, and the experience to run the clinical trials, and assuming those clinical trials are successful, to bring that drug to market. I'm not sure that, in fact, I'll be stronger than that. I am quite sure that we do not want to eliminate that possibility as an exit strategy, because it will affect how much time and investment people like my biology and biochem and whatnot colleagues spend trying to push forward their insights. And the flip side of that is, I think we've discovered that big pharma isn't necessarily the best entity, or those companies are not the best entities at this point to figure out which of those are good to bet on in the early stages. And so I think we are getting more innovation by having that system. Now, that said, we don't want to create a merger system where we allow the companies that have the competitors to those new innovative drug treatments to buy them up. We would like to have them be commercialized by somebody who's likely to offer competition to the incumbents. But I think we want to think about that when we're considering this. And so, we don't want to block the acquisition of small companies in related spaces by a dominant firm, whether it be a platform or not. And I think the challenge is going to be to figure out, how we preserve the incentives and capacity for innovation, but without, as Susan said, allowing the monopoly to outbid others for a technology that might start to create inroads or disrupt the incumbent platforms. I don't think that logically it's difficult to say how we make that distinction, but I think as a matter of putting it into practice in merger enforcement, that will be a definite challenge. And I think maybe a possible, as I said, I think guideline 10 has some great language in terms of, short phrases about theories of harm, but if there's a way to kind of point to how the agencies might assess when it's problematic and when it's not, that would be super useful.
Can I make one final point before we move on? And it's about the role of economists here. So this question of what are the right balance of incentives for innovation between what I'll call the prize theory, that you need to have a huge payoff at the end that's durable, and then the more little guy type of concept. These are questions that I'm made to understand economists think a lot about and think deeply about. Industrial economists have thought about them way beyond what has sort of been entrenched in the law as sort of the heuristics from Bork and Easterbrook. But I also think that they're not capable of being answered in a scientific expert way in an individual case. And so I wonder, while it is totally appropriate and great that we have economists who are expert in this stuff working on the guidelines and working on policy and working on prioritizing cases, if we need to get away from the paradigm of you cannot try a case unless you have an expert in a white coat telling you in model form what is going to happen in this market if A or B happens, because that is essentially unknowable. And I want to just get courts off the drug that they have been fed for 40 years of, this is math. This is something that somebody who is an expert can come in and tell you, this is how you're going to serve consumer welfare. And I don't know how we do that. I think that courts have a learned helplessness here about, I can't do this, and so I need an expert to tell me. And it's kind of ironic because most lawyers and judges will tell you that they became lawyers and judges to avoid math. And yet they seem very unwilling in antitrust cases to do so. So I don't know how we fix it, but I wonder about what this means for the role of expert economists in merger cases.
Can I just say, Rebecca, I think what the agencies have tried to do in these guidelines is to get to exactly where you're asking, right? My colleague, Dave Gelfand, when I was at DOJ, who I understand may not be as popular now that he's back on the outside, but called it the CSI effect. And I don't think it's economics. I call it econometrics, right? It's this sense that if you can't quantify something to the fourth significant digit, it isn't real. And I think, in fact, what the guidelines are trying to do, what I love about this is they're trying to say, we can use economics, like economic theory, combined with our understanding of how the business works and our business documents and so forth, to explain how this harm is likely to manifest. And that's what we need to do, not present an econometric model that predicts the exact future.
I mean, we basically tried in the CMA to do exactly that. And in a sense, we had the advantage that the institutional setup is better. But essentially, a phase 2 merger in the UK, there's a panel of 4 experts, which are a mix of lawyers and economists and business people. And essentially, they are being asked to decide on the balance of probabilities whether the merger is a problem or not, having holistically look at the whole evidence. And the evidence is consumer surveys, internal documents, essentially depositions of market participants, economics, in some cases econometrics, but very much in the context of everything else. And I pushed very hard during my tenure to break down these barriers and end up with a holistic assessment, because otherwise I always felt we will end up in the wrong place. Because clearly, I've done my fair share of econometrics in my early stages of my career. And I mean, we all know it helps in some cases. In other situations, you're just missing the big picture point. And so personally, I really like the guidelines because that's exactly what they're trying to do. And I personally think there's a lot of economics in the guidelines. So the economists who are saying, there's no economics in the guidelines, I think they're completely misguided. But at the same time, I think it's important for economists to accept that there are multiple sources of evidence. There is technical knowledge, there is industry knowledge, there is economic knowledge, and depends on the cases, but you've got to mix them up. Now, obviously, I think Rebecca is completely right. You have a system that has a certain history in the US now, and it's quite hard to move away. But during administrative systems, it does work. If you manage to move away, I think you end up in a better place.
So can I pile on to, I think these are great points and I love the way you all have articulated them. And actually personally, I started my career as a theorist but apparently people who cite me like my econometrics better. So I've been mostly doing econometrics for the last 10 years, but I have done expert work that is not econometric based. And it may be the judges want it, but I think it might also just be that our conventional wisdom is wrong among all the people doing the work, in the sense that we all tell each other that that the role of the economist is to do the regression. And people are a little bit afraid to put documents and firm surveys together with economic theory, even if that is actually what's right, because we don't have as many role models. We don't have as many, we're just not used to it. And it's a harder thing, by the way, to delegate to teams. It's hard to take a team of junior economists and say, like, okay, build this conceptual case. It's not a cookbook activity. So I guess I would actually put out a call to the community to, maybe we need, some more chapters of textbooks about how you do non-econometric economic analysis, especially when it is future oriented. Even though in some sense the theory and the logic are clear, the qualitative incentives are clear, and there's an enormous amount of factual evidence that says which way the magnitudes go. But I guess I still have never figured out exactly how to turn this into a recipe that, could be easily replicated, basically. And I think we just need more case studies. We need examples. Like, we have to keep going back to the same cases, because there's so few of them to look at what the role models are. So I think it's something that I agree with your assessment of what we're trying to do. The risk assessment framework is one of the huge enablers. Again, it's such a subtle change, but at the same time, I think it just opens you up to do this properly. And then the next step is to say, how do we execute this well?
But just to echo Andrea's point, in an advocacy system like ours, I think the agencies can say, oh, we've just got to get better at presenting these more, say, qualitative or theory-based cases. I think when you're before a federal district court judge who has been conditioned to think, I'm expecting to see rigorous, i.e. statistical evidence, and the parties are pushing back against DOJ or FTC bringing a case that's more qualitative, it's not obvious to me that the agency prevails, even if you've, dotted all the I's and crossed all the T's on that. So I maybe the articles that need to be written are more about, we should expect to see kind of theory-based, qualitative, complemented by business documents and practice cases, and convincing judges of that. I don't know.
I see that as my job. I mean, that, I'm a law scholar, I'm not an economist. And I think that, like, I'm really hoping to get involved in more judicial training, and, I want to write articles for judges. I think that there is a level of education and enablement that, I mean, that's what it feels like to me, is enabling the judges to make these decisions, and less delegation to economists or econometrics, if you want to not lump all economists into the equation. But no, I think that is my job, as a job as Legal Academy to make those arguments.
And I think that the challenge that you'll face in accomplishing that, Rebecca, is I look at cases where, let's even just separate the statistical evidence versus kind of other arguments. But, I look at Sprint T-Mobile, or I look at AT&T Time Warner, where the judges just seemed so willing to believe the executives who say, oh, don't worry, we'll compete just as strongly as we did pre-merger. We would never do the things that the government is accusing us of intending to do. Despite the fact in those cases, I think there was sort of compelling evidence and arguments, and the judges, the way I read it, now maybe they just wrote the opinions because they knew what the answer was that they wanted to get to, but it was like, in fact, I think one of the judges said, I looked at the executive and he didn't, I know what it looks like when somebody's lying to me, and he wasn't lying to me. And so, I believe them, and the government's got this theory, insubstantial economics kind of case. but the executive told me they're not going to compete.
Yeah,
So-
that's what Bush said about Putin too.
I have a question for you. How do you see the role of ex post studies? Because, one of the things I did in the CMA was try to do ex post studies both on actual merger decisions and on remedies. So on, fix it type litigation on remedies. Because I think one of the problems in my mind is that, you're trying to run a merger program as a senior person in an agency, and you think about numbers and you think about over the years how things work. But if you're a judge or you're a decision maker who every X years is confronted with an individual decision, and obviously you have this amazing piece of theater on the defendant side with the CEOs and lots of people are extremely convincing. I think it's almost normal human nature that you're going to give the benefit of the doubt about a merger, which is about the future. But if you do ex post studies on, T-Mobile, Sprint, or, in many ways, I think the way I read the DOJ complaint on Athey is a great ex post studies on the Google DoubleClick acquisition, which clearly was clearly a mistake, and that complaint spells out why. So I think agencies personally, I think, should invest more on some of these ex post studies, because then it's the type of thing that I think Rebecca or her colleagues can then use when talking to judges to try to slowly shift this mindset. Because I think it's always hard when you're dealing with a very specific case. But I think if you change the overall way of thinking about merger control and enforcement and balance of risks, I think it's slightly easier than to do it on the individual case.
So I think that's a great point. And I think that really dovetails nicely with, again, why update the guidelines? Well, we've had 15 years to see, whether all of this entry and competition was going to play out. And we've seen that it hasn't always. And so that's one reason we need to spell out these theories more. Coming back to the judicial education point, I do think that is extremely important. I want to push back a little bit that the judges themselves aren't conditioned for the most part, because most of them have seen one or two antitrust cases. So the judges are coming in cold. The extent to which they're conditioned is by the case law. But even there, I don't know how, I'm not exactly sure that it's right, although it's an oft repeated point that they are conditioned directly to look for that. I actually think the ecosystem of all of us is part of that. It's the perception that they are conditioned to look for it. It may or may not be a reality. I think I did some judicial education at some point a long time ago. There was just an interesting anecdote from that where we had a panel and the Economist stood up and said, none of us believe that there are bright lines on market definition in our regular economic jobs. The only time you ever would put up a bright line is for a legal case. I was like, what? People were kind of horrified that there was an artificial construct put up that, so whenever people blame the Economist for things like that wasn't our idea, we're just trying to fit into the legal framework with the economic evidence we have, which generally thinks of competition as being much more continuous. So I think it may not take that much education to say, because I think it's very unattractive to a judge to have an expert sort of testifying very strongly about a point which is a little bit divorced from the science. So I think there's that is a point, by the way, that we did try to clarify more in these draft guidelines to explain why the boundaries are fuzzy and why good economics would often be consistent with fuzzy boundaries. There was old precedent that said about fuzzy boundaries, but what wasn't there before was a clear explanation of sort of why those boundaries are expected to be fuzzy. And I think that also has another analogy. Again, I said this a bit earlier, but with the platforms and studies, if one reason the CEO is so convincing is they are telling a story that's somewhat consistent. They found a way to make it consistent with the way they're operating their business in some way. And if the economic theory and the econometrics are shoehorned into this narrow thing that doesn't really fit into the narrative, that's one reason it's not credible. So although it's hard, I think that what a good case study looks like is that the economics is credible because it makes so much sense and it actually matches up with the facts of the case, and you have figured out how to tell that story together. It's hard, it's really hard. And that's, I think, why we need more case studies. You kind of know it when you see it, but it's hard to tell a team, or even if you're the expert, it's actually hard to accomplish, hard to accomplish that goal.
Well, let's go back to Andrea's point just a second ago and what you said, Susan, about taking account of his point about the retroactive studies and your point about taking into account, what we've learned over the years. The person doing, most of these, retrospective studies is John Quokka. Let me read to you what he said about merger efficiencies at the end of his big meta study. This is a quote. "There is, in short, no good evidence that mergers generally result in substantial and verifiable cost savings, notwithstanding claims to the contrary." So I guess my question is, why do we have that rebuttal section on efficiencies? Where's the studies that show there's efficiencies?
I guess I would say that's actually, I mean, the rebuttal section is, to me, is framed more around showing that your merger is not going to harm competition. So actually, going back to Nancy's earlier point about, are we going to harm biotech innovation because we're saying big pharma can't buy small firms? I can think of lots of ways an acquirer could show that this acquisition of the startup is not going to harm competition. Now, if they just patented a drug yesterday and this is the direct competitor, then maybe it would harm competition. But on the other hand, if this pharma company has a drug that's about to go off patent, and so, that as long as they don't have the ability to squash the generic competition, which is another story, then, maybe in fact, this acquisition will increase competition. And I like the economic frame of, does this hurt or harm competition? So there are cases where I think of the efficiency as a means to an end. We might have we have a small number of firms, like in platforms. We have a kind of fringe platform that is not able to serve a bunch of the customers for a variety of reasons. So from a customer perspective, they think there's only one choice or two choices or three choices. And now we have a merger that's going to allow this smaller platform to enhance their product offerings in a way that for a big subset of customers, that's going to create a new choice for them.
Yeah, but that's sort of theoretical. There's never been any cases where the rebuttal has been used successfully, and the efficiency rebuttal. And in addition, Quokka's saying there's no studies to show there's much efficiencies at all. So should we take that into account?
I mean, that's a big cross-sectional study where we might be thinking about a data point. I think if you look out at any of your favorite monopolies at any point in time, or your dominant platforms, there have been moments where things like what I described have happened, where there's maybe been a merger from some of the fringe firms, or there's been some combination of assets that's allowed a small competitor to restore a more competitive environment. So, I mean, I don't think it.
Remember, it has to get passed on in price, has to be merger specific and verifiable, and we never see that.
Yeah. So yes, but I'm trying to think of a safe case study I can talk about. So if you think about, like, Apple almost died in the late 90s, early 2000s. What allowed it to rise from the dead? One of the things was that there was a certain set of people doing creative work on Apple, and it got the chicken and egg problem solved on creative workers, and then they got enough of those to get enough other apps on it, and then it was other things happened, and it was able to kind of lead us back to, we didn't have a monopoly PC operating system, which I think is good. And if it had been that to make that happen, there was some acquisition Apple could have made, I think, or if there was some third operating system, at that point, probably that would have restored competition, so that for most customers, they would have at least two viable operating systems that had sufficient apps and enough of what they need. So those are the kinds of examples I'm thinking about. I don't think that would show up in an econometric study. So I can both agree with Nancy's evidence and Nancy's work and Quokka's work and others' work that in general, these things often don't come into play. But still, imagine there might be something that's very important for our economy that we would want to allow.
Yeah, can I weigh in on this? Because John Sallet and I wrote a paper on merger efficiencies, and I think it tees up kind of the tension that maybe isn't as explicit in your question, Mark. And that is, so we make a distinction between what we didn't coin this phrase, but kind of a standard efficiencies credit in mergers, which is why we allow horizontal mergers at all, because we think that it is not, while our theory models would tell us that if we allow competitors to combine, we've reduced competition and that leads to some adverse effect. We don't block all horizontal mergers. And so, we interpret that as this sense that there is likely to, in some cases to be perhaps some efficiencies that if the anti-competitive effects are really small, maybe we don't want to spend our resources going after those. In contrast, when the agencies have decided that a merger presents enough potential competitive challenge to do an investigation, then we're in this kind of legal case study world where it's all about facts and circumstances of the individual merger. And parties will come in and try to convince the agencies that there are efficiencies to be gained. And, this is how they're going to be realized. And the agencies evaluate that. The mergers that get challenged are the ones for whom the agencies looked at that evidence and said, yeah, we don't buy it. We don't think that they're either going to be realized or that they're going to be, the whole set of factors, including this new kind of pass-through factor that's been made more explicit in the current guidelines. We don't think that that's enough to suggest to us that the anti-competitive effects are going to be offset by these wonderful efficiencies. And, the example I point to for my students is the Miller-Coors joint venture beer merger, where I think, in fact, the ex post studies suggest there were substantial efficiencies that were realized, and that was, I wasn't part of that, but my understanding is that's why DOJ let that go through. And then Nate Miller and Matt Weinberg have showed that the problem is, yes, those efficiencies were realized, but that joint venture allowed for more effective tacit coordination between ABI and Miller-Coors, and prices went up despite those efficiencies. So I think that gives us kind of this cautionary tale, and another reason why I love the renewed emphasis or greater emphasis on coordinated effects, because mergers are also kind of our last chance to avoid the emergence of more effective tacit collusion, because once we let the merger go through and tacit collusion happens, we're sunk, right? We can't go after that, at least in the US. So I think that the rebuttal, that the availability of an efficiencies rebuttal makes a lot of sense, both because, maybe there are examples like Susan's explained where that would be important, but also from a practical standpoint, which is courts want to look at that, right? And probably even more than we want them to look at that, right? And I think of the Anthem appeal where then now Justice Kavanaugh wanted to send that back to say, do a lot more on these efficiencies. They could be really important. I think as a practical matter that if the agencies just say, we're not going to look at we're not going to listen to, we're not going to look at, we're not even going to consider, that they're actually likely to lose more cases than, as you said, right now, there haven't been any cases where the agencies have lost on efficiencies grounds. And I think we'd like to keep it that way. And I think if they try to ex ante rule out that as a rebuttal, it's going to lead to potentially adverse consequences. If they articulate how tough that standard is, we're in a good position.
But just to push back a little in your paper on efficiencies, which is an excellent paper, by the way, you cite to Carl Shapiro, who says that the standard deduction is not trivial. It's like 10%. And Louis Caplow, also in his article in the Antitrust Law Journal, says it's really high, the amount that we're already taking into account when we set the concentration levels.
Right, which is another reason to applaud the 2023 reversion
Because they brought it down
to 1800. I think the key, by the way, will be, we talked about this, did we have this notion of kind of 5 being the good number of accounting firms, and we slipped below 4. I see in the US that the history of at least the last 25 or 30 years that, part of, and it's explicit by the creators of the 2010 guidelines, part of the reason that we let that move up is because we weren't enforcing lower. And I think we weren't enforcing lower largely because we didn't have the resources to go after all of the problematic mergers. And so we picked the ones that are worse. And I think without a substantial, and I don't think we've gone, we've increased budgets a little bit, but we haven't increased them a lot. I think without a very substantial increase in enforcement budgets, we're not going to be able to enforce to the 1,800 typically either, because the agencies are stretched so thin. So if you believe in strong merger enforcement, I think the first thing we should do is lobby for increased congressional authorization.
Can I say one thing that actually Nancy's comment before just that one made me think of? She said, leave the rebuttal thing in because otherwise you'll lose more cases. One thing I haven't heard, and I agree with that, and I agree with that kind of pragmatic thinking. One thing I would like to see more out of, maybe in the guidelines, but maybe more also in the posture of the agencies today, is a recognition that the 2010 and the 1983 guidelines were hugely influential on courts. And these guidelines are only useful, in my view, to the extent courts buy them on some level and they buy in. And so I think it's really important. It's a theme that I've kind of been talking about this morning quite a bit, but I think that compromise and also framing and also revisions in response to comments is going to be a really important way to get buy-in from the courts, because while the agencies have discretion in the cases that they bring, they don't have the authority to actually stop mergers without the courts. And I guess that's sort of an obvious point, but it's one that I see maybe in particular as a lawyer that I think is getting a little bit lost in the debate over what are the right way to write the guidelines for public policy. I want to see the right way to write the guidelines for the courts. And again, that will necessarily involve some compromising. And it's part of, and I think the good news is, this is consumer welfare. I think that untethering antitrust policy from that would be something that might make these guidelines a bit of a dead letter.
So just to pick up on a couple of these points and go back to something we were talking about earlier as well. First of all, I think it's been a very useful discipline device to look at each guideline and say, can I read this guideline and can I understand what causes a problem, but also can I understand what doesn't cause a problem? Now, some people have asked us to put up safe harbors. Legally, we can't do that. These are guidelines. This isn't rulemaking. We don't get to do safe harbors. So that's a non-starter. That's not in our authority. But I think it is very useful, and we don't necessarily, I was going to say, I have faith in the defense bar to figure out ways to defend their mergers. So I don't know that we need to spell out everything for the parties, but I do think that it's a good critical lens to say, can you tell what is and isn't a problem? And I think one reason is that that's true is what you said about the judges. Like if the judges read this and they can't understand, what it is that is sort of good and bad, then I think they may give less credence to the guidelines. So it's a fine line of exactly how much to spell it out. But I think that I certainly have found that some of the criticisms and the comments and the suggestions that have landed well for me are places where people pointed to something and they said, oh, I'm interpreting this differently. And I realized that we haven't got sufficient precision, to answer that question. While I have the floor, I want to circle back to an earlier point we were making about widening the aperture that I think does make it harder for judges, though. When we talk about the consumer of tomorrow, that has these benefits of aligning it with the truth and aligning it with the actual theory and what's actually going on. So those are all great benefits. But when we think about the consumer of tomorrow, there's also more, defendant-friendly arguments you can make when you widen that aperture. So the one reason to be afraid of this is that we couldn't quantify it. The other reason to be afraid of it is in 3 years, well, there'll be new AI, we'll all switch to headsets, who knows what's going to happen in 3 years. And there's going to be so much entry in 3 years that, all of these problems will go away. And so I think we've been focused a lot on the CSI effect, but that's not the only effect. And that's one reason I think we need more of these case studies And we also need to be very careful about the risk assessment framework. I can delineate for you a clear risk because the motivation for the merger is to put up entry barriers. Yes, it could all change, but you need to convince me, that it's not just pie in the sky, it could all change in 3 years, but that you need to convince me that there's not a very real risk that it won't. And that's where also these learnings come in. Yeah, over the last 15 years, there's always been a risk. Over the last 30 years for some of these firms, there's some risk that they will be displaced, and that risk is always there. But maybe it's not that likely. And so if I can show you that it is likely this is going to be a barrier to entry, and the baseline probability that technology changes and displaces them tomorrow is low, then that's how we would evaluate. We would still think there is a risk of substantial harm to competition. But so that's why I think we're the new landscape that needs to be operationalized and the meat needs to get put on the bones is if we get over the CSI effect, how do we not just open up to, anything can happen in the future, so this is hopeless, and in particular, lots of entry could happen. And so why are you worried?
So, Nancy, I want to raise your article in Antitrust Magazine with Carl Shapiro. And what you say there is that and this is true, almost all of the analysis of mergers in the last 20 years has been about unilateral effects. And economists have worked really hard, and there's these new technologies, upward pricing pressure measures, and guppy and merger simulation. But what about coordinated effects? I mean, there's very little economic, analysis that's being done, maybe Suslow and Levinson's book. But isn't there a lot of evidence, I guess is for Susan, of coordinated effects among big tech companies? I mean, for example, Apple and Google, they're both set their take rate at 30% exactly. I mean, what is your view on how much coordinated tacit collusion is going on with big tech?
So let me say a few things. I'll maybe pass it back to Nancy. So I thought Nancy described this extremely well earlier. I think economists sometimes can have a knee-jerk reaction that, well, why are you talking about concentration? And one reason to talk about concentration is, well, I did a micro model and I looked at differentiated Bertrand and I looked at Cournot and these are the numbers. And so, concentration is just a proxy for some oligopoly model. And that is exactly true and exactly right. And so, but then we shouldn't care about concentration except for as it's a proxy for those. But in the world, when you're down to this small number of firms, coordinated effects is another big thing. And it is also true that it is not unambiguous that a decrease in the number of firms always in every circumstance makes collusion more likely. But I mean, it's the first order effect. I mean, and it's for all the reasons we've modeled. There's mathematics that have a very clear, n-1/n term in them. But honestly, that way understates the case because we haven't modeled mathematically all of the ways that firms think about tacitly colluding. Am I going to enter this country? We've got global competition. I've got a competitor that's really strong over here and we're really strong over there. And maybe we kind of meet up in the middle in one region of the world. And you say, well, do I want to invest more there? And say, well, we do that, then they'll invest more too. And shouldn't we just instead each keep investing in our domestic market and not make any announcements about how we're going into this area? And then we'll both kind of lay off and we'll have a low investment equilibrium in that place where we meet. And, and that kind of stuff is happening all the time, whether it's customer segmentation, whether it's geographic segmentation, whether it's building capacity, and so, the idea that the number of firms doesn't matter for those calculations is just crazy. It's even just the executive capacity to sort of understand and think through the motivations of their competitors and understand and predict how they'll respond. It's just, from a tactical perspective. So I don't want to speak about any particular industry, but I think, the number of firms is important to economics and to economic theory and to economic mathematics and to economic econometrics about coordination, but also well beyond what we've been able to quantify, but is still good economics.
Yeah, I would just say we should celebrate 2010 and its emphasis on unilateral effects, because that gave enforcers an additional set of tools to challenge mergers, appropriately so. So I don't think that's a negative. I think, part of what we've seen is it is difficult to convince judges on coordinated effects grounds. And, as Susan so eloquently just said, and as I'd kind of alluded to earlier, I think that is one of both the arguments and benefits of pulling the concentration thresholds back down to 1,800, because, I think if you've only got 3 or 4 firms, and we were in fact having to litigate mergers to duopoly or monopoly, which is insane, right? If you think you've got an effective deterrence system, then when somebody comes in proposing a merger to duopoly, let alone a merger to monopoly, you just look at them and say, really? Like, you're going to end up in court and lose. And if it's effective, you don't see those. So I think pulling the concentration thresholds back down helps us with those coordinated effects concerns. It'll still, I think, be challenging to bring a case that is purely a coordinated effects case. But, I was encouraged in the publishers merger. The judge took very seriously the DOJ's arguments and evidence. Now, that was something where you had the benefit of a win by DOJ in court on actual collusion. So, is that what it takes to win coordinated effects? I hope not. But
one other thing that we put in that actually has gotten very little comment, but I think is small but important, is also the history of collusion. I don't think it's a requirement that you have a history of collusion, but also, you see mergers coming in from serial colluders, and that's sort of crazy. So making sure that we call out clearly that, that a history of collusion speaks to a lot of things. It speaks to the factors that would enable collusion. It speaks to the potential returns to collusion. It certainly discredits an executive who says, I would never do that. But that is something we've spelled out more clearly just in these guidelines. But I think this also gets back to our earlier discussion of what do economists need to do. I certainly, actually it's a story when I got into economics, and the essay I wrote for graduate school was about detecting collusion at auctions. And it's been a lot of my early work was on collusion. But I built empirical models to try to assess collusion. But in practice, it is really hard. I would certainly be nervous as an expert going up and trying to do a qualitative collusion case, because there's not as much foundation. But maybe that's a problem that we as a community do need to solve. We need judicial education. We need people to write out what these cases would look like. We need to educate ourselves and agree on what we think is decent evidence. So I would put a call out to the community that if we think this is important, we need every aspect of the research and thought leadership, toolkit to elevate this, so that the work that we do better matches the economics and the reality.
We have about 10 minutes left. So 1 or 2 audience questions. Yes.
Yeah, I think there seems to be a tension. So on the one hand, Rebecca says that 2023 guidelines maintain a consumer welfare standard focus, and I think seems to put that in everybody's comments or explicit. But it also seems that all of you are saying that the practical problem is that it's so difficult for agencies to show that, let's say, prices are going to go up as a result of the merger, that they over and over again lose cases. And that seems to be, as long as you're telling courts that the consumer welfare standard prices or something is the ultimate normative concern about mergers, the courts are naturally going to be focusing on that. And so if the defense experts come in and show that actually there's no reason to expect prices to go up, all the stuff, all the qualitative stuff, the coordinated effects analysis, which would be kind of qualitative, all that stuff just won't look very persuasive to the court. And no matter how much judicial education you give to them, so what I wonder about is whether the solution to this problem, if it's a problem, is just to have stronger bright line rules. Which really goes to this question of whether efficiency or other models should be as strong as they are. Because, I actually, Nancy, I don't agree with you. Most of the courts seem to want to not have anything to do with efficiency. They cite Philadelphia National Bank, and they say, well, the Justice Department's guidelines talk about efficiency. It could be better just in case it's part of the law. But if you got rid of efficiency, you just made the model even more difficult, and you put as much weight as possible on the HHI thresholds. That's what would strengthen that's what would strengthen enforcement. Well, and I guess just to try to make the point a little, to put it as a question, couldn't the agenda be to try to show that what the optimal HHA guideline, taking account the false positives and false negatives. So you'll block some of these mergers, let's say the Apple type merger that would be good. But you would save enormously on these enforcement costs, all of these cases that are lost because it's too difficult to show as a practical matter the prices can go up or not go down in a world in which judges have internalized this notion that consumer welfare and evidence of good evidence of consumer welfare affects what
Doesn't Quokka show that in his 1990 paper that?
But Nancy and I think Susan and others are saying is that he's looking at averages, and certainly there are going to be cases here and there where there's a good efficiency argument.
No. He says that if above 1800 HHI, in his retrospectives, you capture almost all of the mergers where there was were adverse price effect.
Let's just be clear, unless, and I may not be cognizant of all of John's work, but much of John's work on efficiencies is kind of a retrospective of retrospective. So it's not work that much of it's not work
I was
that
talking about the other paper where he looks at, if we just used the HHI,
he's looking at the FTC cases, right?
but not the efficiency part, just where he was just looking at the HHIs and he said, if we just use the presumption and that's it, we're going to capture, 90%
Right.
of all
But I
mergers
just
that
want
are.
to be clear that there, but also like all of, there's a lot of selection in what's being studied there. And I don't think looking in that study and most in the rest of the economics profession are not looking at kind of the universe of mergers. And so I think this comes back to kind of, if we're just looking at the ones that the agencies are concerned about, how is that selecting things? And then if we change the criteria for that, can we still make the same inferences? I guess just to Eric's point, I first of all despair of having any credible economic study that is going to ground an HHI concentration threshold as the be all end all definitive, here's where you should draw the line for mergers. Most IO economists really don't like any kind of HHI analysis because again, in the wild, if you're not looking at this from a merger perspective, like high HHIs might be associated with very good outcomes for everybody in the market. So I'm not sure that's feasible, even if we could do it. And the second thing is, I'm not sure the agencies get to make that call. It goes to Rebecca's point. What I'm really concerned about with these guidelines, where I think in some cases we're stretching further than there's kind of a good body of evidence to support, is that it's going to end up with the whole guideline exercise being diminished. And so, I don't think FTC and DOJ get to say to the courts, there's this bright line rule and above 1800, you can't merge, Your Honor. That's the standard.
I mean, you might be right. I mean, you very well might be right that it's too late. The agencies did introduce the efficiency rebuttal, and maybe they can't take it back now. But there are lots of circuit courts that just say there is no such a thing. They don't accept the agency's view. But that's the thing is that I think this is a real divide between economists and lawyers. The law is full of these arbitrary seeming, rules. And if you replace them with like a rigorous welfare analysis, there would never be any enforcement. So I'll give one example, like campaign finance donation limits. If you had to prove, so if somebody gives more than whatever it is, $10,000, whatever it is to a candidate, they go to jail. The agency doesn't have to prove that any harm was caused to democracy or to the opposing candidate or anything like that. And the question is, what, and I think this is how actually the Supreme Court was thinking about things in the 60s. They were saying, well, we don't know what's going to happen. You can't expect us to figure out whether this merger will, actually benefit Philadelphia because there'll be more business taken from New York. So we're just going to say like 30%, whatever. That'll stop. So then the question is, maybe it's stupid. Like maybe it's just so arbitrary as to be a stupid way to approach things. But if the alternative is, super under enforcement because of these different, is it really inconceivable that a bright line rule can't be?
So if you were asking me, were Congress to write a law that said mergers above HHI of 1800 are banned, I think Congress could do that and courts would presumably have to enforce it. And then we would have, spend all of our time litigating what the appropriate market definition is, which is kind of what we do now anyway, right? But it wouldn't eliminate that, and it would just refocus attention on that. But I just think that's different than DOJ and FTC saying to the courts, there's a bright line rule, no merger above 1800 is allowed, no rebuttals.
You say no, this is a mistake, or would you say this is a good approach to have a bright line rule of 1800 or whatever number you want?
Yeah, I guess I lean, and this is where, my economics credentials, at least in some groups, might be revoked. I lean toward thinking merger enforcement costs are so high, and that also creates costs for companies because of uncertainty. I'd be in favor of probably, I have to think about it, but something like that, some more clear bright line rules that maybe don't allow some mergers that we would think were benign, but mostly are just going after mergers that are problematic. I think that would be an improvement, especially since the courts seem unwilling or unable to get us to that point now.
Rebecca,
Yeah,
last point, see if you support the other law professor.
Okay, no, so Eric brings up something that I think is really important, which is, sorry, I just lost my train of thought.
Take your time.
No, it was before that. It was consumer welfare. There we go. Okay. The idea that you can show that a merger does not, or conduct does not result in harm to consumers totally misunderstands the ends and the means of the consumer welfare. So I think the fact that we call it a consumer welfare standard invited this kind of wrong thinking, which is that somehow because antitrust rules are supposed to vindicate consumer welfare, you can then go in and directly show something about consumer welfare. And it's a defense to the fact that you increased entry barriers, that you increased concentration, that you did all these bad things that may be bad for long-term consumer welfare. You can come into court and you can say, yes, but in the short term, look, don't we really care about consumer welfare? I think that totally puts the cart before the horse and confuses what antitrust is about, which is about regulating the means, the competition towards an end. The First Amendment is the same way. The First Amendment has lots of good reasons why we have it, but we can't directly say this is good speech, this is bad speech. And so we have all these kind of process rules that work well or not well, maybe, and we tinker with them with the eye towards what we want to get out of the First Amendment, but we don't do it directly. In antitrust, we lost that, and we're doing it sort of directly. And I think implicit in your question is, okay, but how do we fix it? And that's a much harder question to answer, I think. I tend to agree that pushing too hard with the guidelines will be counterproductive. And maybe we need congressional action. Well, guess what? We're not going to get that. So I don't know, maybe we do it the same way that Bork, et cetera, did it, which is, show the courts there's a problem. Give them a way of thinking about it that's relatively workable and understandable, and explain that ultimately this law is to protect a process, and not to directly address the outcomes. And then incrementally, very slowly, case by case, turn this ship around. I mean, I guess I have to sound at least somewhat hopeful about that possibility.
Well, we're out of time, but let's thank our panel. They were great. Great.
Fun.